All right, here we are, Q&A. Who do we have on deck, folks? There is a Q&A chat box that should be available over in the chat stream. And everybody is welcome to drop in any questions you have. I'm just sitting here on a Wednesday afternoon getting some work done. Had a little bit of opening on the calendar, figured it'd be a good opportunity to be available for questions as they come up. So let's get the questions going. You guys are, let's see here. Let me drop our system to the chat. So the chat will be over here. It should pop up. What kind of emoji we want to throw out there? Let's throw a monster emoji. All right, you guys see the monster emoji. You see my chat box. And there you go. Clear some of these notifications that are popping up here as well. All right, so let's get over to my management screen. Hang on a second. Why is it asking me to log in? Don't you guys love all this stuff makes you log in 14 times? Yeah, and there you go. Now we got to enter a code. All right, we should be loading up here. All right, let me find my correct spot here. Good. All right, here we go. Let's see, what do we got here? Scrolling through. All right. We have an appointment with a lawyer next month, just trying to get ahead of an idea that we are facing. In planning for his retirement, my father-in-law sold his home to the grandkids for $1 several years ago. I already know where this is going. My father-in-law sold his home to the grandkids for $1 several years ago. The deed is now in the grandkids' names. Pretty sure he was thinking he was protecting the home from Medicaid if he or my mother-in-law needed long-term nursing home care in the future. Father-in-law passed away last year. Oh my gosh. And now mother-in-law wants to be able to sell the house and downsize one day in the future. She wants the deed back in her name. The grandkids are fine with signing it back over. Okay. Whew. But I'm concerned they'll have tax implications. The property's worth about $300,000. Can the grandkids sell it back to her for $1? What kind of tax issues might arise? Well, not the first time I've seen this happen. So essentially what happened here, the grandparents didn't sell it for $1. That's just sort of a thing people used to do. It was a gift, right? And so back then, we don't know when it was, but when you gift property, it's been the law for a long time that the person who receives it actually accepts the property at your basis, your cost basis. Okay, so whatever they bought it for, that's now what the grandkids' basis is. Father-in-law passed away. They lost an opportunity there. And now she wants the deed back in her name. can the grandkids give it back to her? So, oh, excuse me. So what'll happen is they'll they'll make a gift back to grandma, and their basis will be given to grandma. Grandma will have will have their basis. Their basis was grandpa's basis. So here's where they lost out. So they won't actually end up with a bunch of tax issues. The gift tax limit is each of us have a lifetime limit of like 12 or 13 million dollars right now. So that's not a big issue. The bigger issue is if you are um, wanting to know what tax opportunity did they miss. So when you own property, when you own a house and you pass away, it goes to that next generation with a new basis that steps up to the fair market value as of the date of death. They didn't get that. So if grandpa and grandma's basis was $100,000 when they bought it, he passed away, say it was worth $250,000, but instead of him owning it, he gifted it to the grandkids and they're going to gift it back. Grandma could have had a step up in basis of that $150,000. So not anymore. Now that $150,000 is not stepped up. So grandma's got a basis of whatever it was way back when. So that's it. That's really the only tax issue I see for that situation. Shouldn't be too much of a problem. And just let me know if I didn't get that question answered. You are welcome to drop me a chat. Good, good, good. Okay. Let's go to the next question. Sorry, I'm just cruising through the questions. A couple of them are more investment related. I'm going to kind of skip those. Today is really estate planning, probate, trust. I guess I'm happy to do some investment related questions, but that's supposed to be on my other channel, Lifestyle Planning. So we're going to try to focus on the estate planning stuff. Oh, here we go. Can you name this is a little bit of both, but we do this all the time in the estate planning side. Can you name your trust as the beneficiary of your retirement accounts? So retirement accounts, generally speaking, no, you don't want to do that. You want to wait and let those go to an individual. There's certain types of trust that are really good strategic options. Yes, that you can get a little bit of extra distribution length for the kids or grandkids or whoever. You can get some extra tax strategies built into it. But just a regular plain living trust, you generally don't want that to be the beneficiary of your retirement account. All right. All right. All right. Very good. What else? All right. Well, we'll let it hang out and we'll see if anybody comes back with more questions. Just going to hang out, keep working. Questions. I'm here to answer questions. What do you got going on? Just a lawyer hanging out, ready to answer anybody's questions. Just drop them in the chat there. Hmm. See, these are the kind of questions that I deal with. So, someone's looking at this investment. It's a private investment deal. Some fund that has been created. And here's how they describe how they make money: processing and underwriting fees of securities, mainly debt. What does that mean? What does that mean? I don't know exactly what that means. I mean, so what they do? They make money by processing and underwriting securities and debt. So their clients pay those fees. Okay. So they somehow get paid to do that, and they have created an investment to leverage up those services. Hmm. No guarantee of anything. What's the potential downside risk? You could lose it all. No guarantee of anything. All right, so it's a private investment. Unsecured, no collateral. Company fails, your only hope is through bankruptcy. Does that sound like a good deal to anybody? I'm a little suspicious. But hey, you know what? People invest in all kinds of things and make money. I don't claim to know them all. Uh, okay, so then they've got two funds they're advertising on their website. One's a real estate fund and one's a bond portfolio. Big deal. All sound like what they sent in their email. Okay. I don't really see anything on this page. This is about the most vague page I've ever seen. They don't have their disclosures, their prospectus. They've got none of it. Okay, whatever. I guess we shall see. Probably going to hang out for another few minutes and then wrap it up. Any questions, feel free to throw them my way. Okay, well, we're going to wrap it up here. Let's button up our Q&A. Any other questions, you're welcome to send it to info@keystonelawfirm.com. And my team will help you out. Just drop the email there in the chat box, info@keystonelawfirm.com. My name is Francisco Sirvent. I'm the owner, founder, top dog at Keystone. All right, thanks everybody.